The matter came up today to confirm compliance of court orders from the Makuyu police. The DCIO David Cheruiyot has been in disobedience of court orders since the case began. We have tried to engage the court, who gave orders for accused persons to be given the right to fair bond terms, but they were unable to access any of their bond or cash bails, which they can only do through their mobile phones. This is the truth the world over. Safaricom SIM cards will only work when you're within the country. The same for people who are outside. The DCIO was given many opportunities to come to this court, give the phones to the individuals so that they could take out their M-Pesas, pay their cash bail and receive and go home. It is a constitutional right they are granted to be able to pay cash bail, and until they are convicted of a crime, they should not be treated as convicts. So the matter did come up today before the magistrates and has been in the media for the past few weeks about disobedience of court orders. And the same is quite insidious, considering the Chief Justice, the Deputy Chief Justice, the magistrate of this court, the prosecutor of this court, they are all women. And the people who work for them and with them, the police, are all men, and the orders are not being followed. We do call for respect of court orders, for the treatment of all people, international, national, or otherwise, fairly and with parity. Leaders in positions such as the DCIO and other public officials should be striving to treat people with equality, fairness, social justice, before they choose to treat them as convicts during a COVID pandemic. Throwing people within the jail system, as they did to these internationals, causes such things as COVID-19, which the accused persons ended up getting while they were in custody. The court has tracked this case for over the past 2 months, and the conduct of the police has been found absolutely wanting. As a matter of fact, one police officer acting under the DCIO, that is the deputy, Mr. Washuma, was sent to court to lie that they never got court orders, whereas that same officer was in court and given orders by the judge, mouth to mouth. The orders were served by them digitally, they received them and served them back to us. They were aware of this case. They have chosen to cause a gender crisis in the courthouses of Kigumo law courts, because if the police cannot follow the courts, why would they subject the rest of us to follow the law? We are calling on the immediate release of these people, and the poisoned chalice that is this case be allowed to submit and end. And let that be a lesson to the police, whether in Makuyu, whether in Nairobi, or anywhere else in the jurisdiction, that unless they follow the law, there is no way any of us will agree not to be unlawful. Lawlessness cannot be the way the court shall operate.
DCI was served by the orders of this court, and also having found that he has chosen to ignore those orders, that failure to obey the orders of this court means that the DCI Makuyu Police Station is in contempt of the orders of this court. This court therefore issues a warrant of arrest against the DCI for him to be brought before this court for further directions. Being unlawfully present in Kenya, contrary to Section 53(1), as read with Section 53(2) of the Kenya Citizenship and Immigration Act, the two accused persons are found guilty as pleaded. So this court takes judicial notice of the COVID-19 pandemic and the national and international lockdowns and travel restrictions that have been put in place from time to time in order to control the spread of the pandemic since early 2020. From the dates of the expiry of the visas by the two offenders being 6th of April 2019 for the first offender and 13th of January 2020 for the second offender, it would seem fair to hold the second offender's past expiry is within the ambit of the pandemic lockdowns. The first offender, whose visa expired on 6th of April 2019, way before the pandemic hit cannot avail such mitigation in his favor. Therefore, this court will require a pre-sentence report with regards to the first offender for advisement on sentencing. As regards the second offender, predicated on the expiry date of his visa, being 13th of January 2020 when the pandemic restrictions were prevalent, this court will discharge him under Section 35 of the Penal Code on condition that he regularizes his stay in Kenya within 21 days from the date he will be released from custody. To that effect, Exhibit number 2 be released to his counsel forthwith. Date for sentencing of the first.
Yeah, in response to the, I've been told to respond in the month of 31 that this person's phones. We did not receive, or the DCIO Murang'A South did not receive the order, and therefore he could not act. He wasn't served with the orders. Yes, Your Honor.